and I still don't know their name.
So you just turn around and
Hey, it's great getting old. Still already you can hide your own Easter eggs.
no, that's
Just say so.
the mother-in-law said I meet new people every day.
That's it.
Plus it feels good.
See new places.
I did this job for 21 years.
Time.
Until I don't get elected here.
What's the missing here?
I'll die. Dave has to recuse himself.
I know. That's it. That's all we got.
Good evening, ladies and gentlemen. The clock has struck 7, so that means it's time to start. I'd like to call this a meeting of the Town of Wolfeboro Zoning Board of Adjustment to order. To my immediate left, my name is Fred Tedeschi. I act as chairman. To my immediate left is Sarah Silk. She's our vice chair. To my right is Peter Colcord, a member. To his right is Luke Freudenberg, also a member. And to his right is Tim Cronin. He's also a member and acts as our clerk. This evening we have 2 items on the agenda, and would the clerk please read the first one?
First item is tax map 217-196, case number 01-V-19, applicant Jared Burke and West Burke. Public hearing for a variance under Article 10, Section 175-144B of the Wolfeboro Planning and Zoning Ordinance to allow for the renovation of an existing barn, to allow for 2 additional residential units. Property is located at 112 North Main Street. A site visit was held a little after 4 o'clock today, attended by Chairman Fred Tedeschi, myself, Tim Cronin, Dave Senecal, Sarah Silk, Peter Colcord, and Luke Freudenberg.
Thank you very much. I'd like to mention that Dave Senecal, who's our alternate, will not be sitting for this case. Please identify yourself for the record. This is being recorded, so you have to.
Very good. Good evening, members of the board, Mr. Chairman. My name is Philip Marbury here from the law offices of Marbury and Marbury on behalf of Frank West and Jared Burke, my clients who are here and seated to my left. We're here requesting that this board grant a variance, and the details are obviously all in the information that has been supplied to the board, but I want to give kind of a big picture of what the Burkes are hoping and planning to do and why this is a good thing for the town of Wolfeboro and why this is not something that should be denied, the variance request. And then I will go specifically through the 5 points that must be satisfied in order for a variance to be granted under the New Hampshire statute. Big picture, what the Burkes are looking to do is to take an old barn that's located on this property that is already a multifamily unit. There's a building there with 4 units inside of it, residential units, and what they're seeking to do is take an old barn that was built in the mid-1800s and basically bring it up to its highest investment.
Yeah.
Most important person at a meeting is the guy who has the batteries.
Test. All right, there we go.
Thank you.
And so what they're wanting to do is take this barn that right now serves no purpose. Right now it is essentially a liability because the purposes that it was built for, right, which are primarily agriculture or commercial industrial, no longer fit in this community. They no longer fit in this area in the village residential district that the property is located within. And so the Burkes are simply seeking to take that and make it a productive asset, to turn it to its better use. And in the process of doing that, they are very conscientious and aware of the desire to maintain the character and nature of this neighborhood. They're wanting to do this renovation in such a way that's going to preserve the visual appeal as it stands now, and the documents have been supplied for the board members that show the kind of the anticipated face of this building. You know, the biggest change really are just the addition of some windows, and there will be other very minor changes because they're going to ensure that this is built, you know, according to all the applicable code and permitting, because that there are going to be some things that they're going to have to do in order to comply with those requirements. But their goal is really to ensure that it maintains the historic and visual appeal that the building currently has. In fact, this renovation and update is going to be more beneficial long run, because as it stands now, as I mentioned before, it really is kind of a wasted asset. It's property that has no actual function as an old barn in the middle of the village residential area, this district. And specifically in this part of the community, that is, the idea of multifamily residential dwellings is not abnormal here. There are many other properties in the immediate area that have the same type of multifamily residential purpose. There's, I think it's 3 lots down. There are 2 adjacent lots that comprise a total of 11 residential units on just under 0.7 acres. So, when we talk in a minute about population density, the specific thing that we're seeking a variance for, this is not out of character for the neighborhood that we're dealing in. And again, what ultimately is going to happen if this is allowed is that this property, which is right now essentially 1/3 wasted, is going to be brought to a better use, and it's going to be a positive benefit to the community. As everyone here knows, one thing that we can use more of is quality residence for the people that live and work year-round here in Wolfeboro, and that's what this is really designed for. We don't have issues with the tourists, and we welcome the people that come in the summers and make this their home for that time. But one of the things that, especially in recent years, has become a need in our community is good quality but affordable housing for people that live here. And so that's what they're seeking to do. They're seeking to add 2 more units to what is already 4, and so it would eventually become 6 units. And they've proven themselves to be good quality landlords. They maintain the building well. As you all saw when we were there, the existing structure is very well maintained, and they simply want to continue to turn the rest of this property to that same beneficial purpose. Now, in order to qualify for a variance and obtain a variance from you, we have to establish that the 5 criteria for that variance are met. And so I'm going to go through each one of them. There are some of the factors that we need to consider for each of these that are going to be duplicative, so I'll do my best to just reference them and tie them into each category without necessarily going at length into all more than once. The first thing that we need to establish is that the variance would not be contrary to the public interest. And I think that this is very apparent by a lot of what I've already said. The purpose of the zoning laws in section 175-68.1 is specified as to provide, or specifically for the village residential district, one of its purposes and intents is to provide higher density residential dwellings in a range of dwelling units within the built-up area here in Wolfeboro. And this is perfectly situated to achieve that goal. It's kind of on the way out of town, as you all, again, are aware from going there. It's just up at North Main Street. On the way out, it's within walking distance of what we kind of consider the commercial hub here in Wolfeboro. So it has really great access from pedestrian traffic, and people that can live there can easily walk to work here in Wolfeboro for different businesses. It is very much in line with the idea of creating that higher density residential availability for people that are going to live and work here, who it may be more difficult for them to commute from the more rural areas outside of the town. And so it meets that obligation of the specific purpose and intent for the village residential district. It's also, as I mentioned before, it's located in an area that this is not abnormal for. It simply is expanding and improving upon a situation that already exists in this area of Wolfeboro. There are many multi-unit dwelling buildings in this area, and this is simply taking one that currently has 4 and adding 2 more to again improve its function and purpose to that end. Finally, the renovation of this is a long-term benefit to the community because it takes something that otherwise would be very prone and likely to be neglected, over time run down because it has and serves no purpose, and it gives it a reason, gives the owners a reason to ensure that it is maintained, and that it is renovated to be a continued visual appeal for the neighborhood and for this community. One of the things we hate to see here in Wolfeboro is when these beautiful old buildings, they lose their purpose, and so they just get abandoned, they get neglected, and eventually they either get torn down or are just neglected and become an eyesore, and we hate to see that. And so our my clients here are seeking to do something that's going to help prevent that from happening in a way that's beneficial to the town, to the community, and to them. So I do not think that there's anything about this that is contrary or debilitative to the public interest, thereby meeting criteria number 1. Criteria number 2 specifies that the spirit of the ordinance must be observed. And here we believe that the spirit of the ordinance is observed for some of the reasons I just specified, that it actually goes along with the purpose and intent of the Village Residential District. But also, there's not going to be any adverse effect on public health, safety, convenience, and general welfare of the residents of the town of Wolfeboro. Article 1, Section 175(1) is where that is specified as the general purpose of the zoning laws. And this is not going to run afoul of any of that. So the spirit of the purpose of these laws is going to be maintained. Additionally, this is not going to represent an undue burden or increase. It's simply an improvement and modification of a circumstance and situation that already exists here. This is already a property with multifamily dwellings on it, and we're simply seeking to make that better. Furthermore, one of the other explicit purposes I talked about of the Village Residential District is higher density residential dwellings in the area. If everything is just single family homes, that can be great for certain parts of our community, but if that's all we have, then we begin to have a lack of something that we really need in this area. And especially when we get these areas closer to the middle of town, this is where we want that higher density dwelling. And so that's, again, this is helping meet that need of the zoning ordinance. It's also worth mentioning here that it's really beneficial that the parking situation at this particular lot is already in compliance with what the zoning ordinance would require. The zoning ordinance would require 1 space. The current zoning ordinance requires 1 space for any unit, plus an additional space for every 3 units. In this case, because the total would be 6 units, that's 6 spaces plus 2, 6 divided by 3, and we get a total of 8 parking spaces required under the current ordinance, which is exactly how many parking spaces are there. And so again, it complies with the spirit of the ordinance by meeting these criteria, by actually enforcing and coming alongside the purpose of the village residential districts, and that's why we believe that the spirit of the ordinance is observed and criteria number 2 is met. Criteria number 3 requires that we show that substantial justice would be done with the granting of this ordinance. Again, a lot of the reasons that this is true have already been articulated, but more salient specifically to this issue is to evaluate the effects of what a denial of a variance would actually effectively do here. A denial of a variance in this fact would relegate this barn, which is effectively a third of the property that we're discussing today, to a continued existence of waste. A continued existence where it has no functional purpose. It doesn't do anything productive in our community. And my clients, the owners of the property, would be left unable to make it productive because its current functions are agricultural or industrial commercial as a large barn in town. And there's just not a lot of function or need for something like that here. We've seen it in other buildings throughout town where these kinds of structures, there's a beautiful visual appeal to them, but to continue to use them in the way that they were built for just doesn't make sense. And particularly here, that the owners of the property would left without an ability to make this a beneficial piece of property. The barn itself would just continue to be a vacant structure without purpose. And so it really would be justice to allow this variance because, and it's going to get into the fifth requirement, but the unique characteristics of this property really require that something be done with this barn because its existing purposes, its pre-existing purposes just are no longer relevant today. Number 4 is that the values of the surrounding properties will not be diminished. And I think that this is one that is fairly easy to establish. Taking an old building that is not in good condition, good repair, and serves no purpose, and improving it by simply redesigning, renovating, improving the internal of the structure to make it a really valuable asset, a 2-unit residential dwelling, only improves the value of the property. There are some times and some circumstances where the addition of multi-unit dwellings could decrease property values, but those are not what we're talking about when we're talking about an area that is already really has a lot of these multi-unit dwellings already there. If this were a community or a neighborhood where every single house was a single family house on large acreage, then yes, putting an apartment complex in the middle of it would certainly be problematic for purposes of property values, because the nature of that community would have been such that that's a radical and drastic change. But in the area that we're talking about here, where this is only one of many multi-unit structures, the addition of two more, the renovation of a useless building into a productive building, will only see an increase of property values. It'll increase the value of this property and vicariously increase the value of the property surrounding it. So I don't believe number 4 is really of much concern at all in this case. Then we come to criteria number 5, and this really is the linchpin of almost all variance requests. This is the thing that tends to be the make or break it. And it's a mouthful because of the iterations that we've had to go through as a state, and the courts and the statutes and the legislations. It's a mouthful even to articulate the thing we have to establish, but I've tried to do my best in paragraph 5 that I've submitted, and it states that the literal enforcement of the provisions of the ordinance would result in an unnecessary hardship because the special conditions of this property distinguish it from other properties in the area, such that no fair and substantial relationship exists between the purposes of the ordinance applicable to the application and the specific application of that provision to the property, and because the proposed use is reasonable. This is a standard that is taken directly out of the new statute that was created in response to kind of the court mumbling its way and fumbling its way through how the old statute was going to be applied. But ultimately what it boils down to is this. The denial of the variance in this case would create an unnecessary hardship, and the courts have gone to great lengths to try to define what an unnecessary hardship is, but it does take into account the special conditions of the property. The court has made it very clear that in order to establish unnecessary hardship, we do not have to prove that the property would be useless in its entirety without this variance, right? We know that's not the case. The property continued to be used as a 4-unit dwelling, right, even if the variance is not granted. But that's not the standard. The standard isn't that the property becomes totally useless without it. The standard is unnecessary hardship. And the court has repeatedly, even after the revision of the statute, referenced that the special conditions surrounding the property help inform the board as to whether an unnecessary hardship exists, and that the proposed use be reasonable is kind of the second stage of that evaluation. One of the cases recently that came out of the New Hampshire Supreme Court in Harborside Association versus Parade Residence Hotel, the court in that case relied on the fact that the zoning board had said the size of the building here, that was the single determining factor, the single special circumstance warranted. It was such a special condition as it warranted a variance as to the sign requests, or the sign ordinance, allowing a larger sign to be visible on the larger building. But again, it gives us insight into what the law and what the courts are wanting to see when it comes to this issue. And here are the special circumstances that apply to this property. Number one, it is a very unusual property in that it's old structures, old buildings that are half useful because half of them have been updated, renovated, brought to current use with the 4 units, and then a third approximately, this entire barn, that essentially has no function in its community, in its neighborhood at this point. That itself is a special circumstance. There aren't many properties in this area that have a combination of multi-use, multi-family residences with a large commercial or industrial or agricultural barn attached to it in the village residential district. And it's such that condition and circumstance itself is such that it renders it, as I've talked about before, without a viable purpose for this entire structure. And so that creates an undue hardship that and to really evaluate this, in some ways we need to get to the constitutional underpinnings of why variances are built into zoning ordinances, right? They're built in because when we create zoning ordinances, we establish restrictions that prevent people from using their property, one of our inalienable rights in this country, to the purposes that they want to use them for. Now, we have ultimately determined as a society that some restrictions are proper and appropriate, some restrictions are for the good of the community, but the reason variances exist are to ensure that those restrictions don't get applied in such a way that they just become unnecessarily burdensome. And that's what it would do in this case. The structure exists. The barn, as it stands right now, is already there. And changing the interior of the barn from a very useless may be too strong of a word, but an unproductive vacant barn to something that is going to be beneficial to the community and to the property owners without affecting the structure itself. So we're not causing a substantial change to the footprint. We're not causing a substantial change to the parameters of the building itself. To prevent that it would perpetuate this waste. It would perpetuate this problem of an entire building and structure being with no purpose. And so that is why it would be an unnecessary hardship to apply the strict zoning ordinance preventing this barn to be converted into essentially 2 more units. Additionally, the proposed use is reasonable. That's something we have to touch on here because that's kind of the second prong of this test. For all the reasons we've already talked about, the intentionality of my clients in wanting to preserve the characteristics and visual appeal while bringing this into a more productive use, there's really very little downside to this, especially in light of the fact that one of the biggest concerns would be parking and whether there's sufficient parking for 2 more residential dwelling units at this site. But because the parking currently existing is already in compliance with what would be required at any other place that would build a 6-unit residential unit building, we don't have that concern here. We've kind of obviated the need to worry about that. Again, it's really just also important that the New Hampshire Supreme Court has made it clear that any hardship suffered by the applicant as a result of the interference with its right to use the property without commensurate public advantage is an unnecessary hardship. Again, it's weighing the fact, it's saying if there's a really strong reason that we have this restriction, then it may not be unnecessary hardship, even if it's a hardship. But if the hardship is coming without a commensurate level of justification, then it's unreasonable, and that's why a variance should be granted. Because we have met all 5 prongs of this test, we've satisfied the obligations, or at least we hope that you agree that we have satisfied all 5 of these. We believe that this variance is a reasonable request that should be granted so that my clients can finish and build the 2 additional units in the barn, bringing it to its best and highest purpose. Thank you very much.
Thank you.
Do you have questions at this point?
Questions for the applicant?
You had indicated the barn was built in the 1800s. When was the house put in? Same time?
Yeah, I do believe the 2 structures were built together. It is a bit of a strange history, as you all saw when we were there. Originally, there was this kind of facade wall when my clients purchased it that connected the 2 buildings, but it literally was nothing but a facade wall. It was just on the front. The buildings themselves were still not connected, but we believe they were built at the same time.
We have in our information from the town planner that in 1979 the property was granted a special exception, converting it into the 4 apartments. At that time, what was the barn being used for?
I don't know. I know historically the barn had been used for, I'm going to have to actually ask my client for the term. Historically, the barn has had, things such as hootenannies. Again, I'm not 100% sure what that is, but the idea is that it was kind of an agricultural barn that had music, that had other purposes. It's been used by Dive Winnipesaukee, I believe, for storage and commercial purposes. So it has a history of this commercial, industrial, and agricultural use that, again, increasingly in the area that it is just not a viable or productive use for it in that area anymore. And so my guess, although I couldn't speak with specificity as to 1979, that was well before my clients owned it, is that it did serve one of those original purposes or had just not yet been thought to bring current.
I have a question for the town planner. In our packet, we had our notice of zoning decision from Corey Ryder, and in that paperwork it said was to create a 5th unit in the attached barn, and yet the application is up to 6. Would you like to speak to that, or do you have an explanation for that?
Sure, I can quickly address that. So I spoke with Mr. Ryder. I spoke with Mr. Ryder. That was an error in his initial response, but he is clear that the proposal is for 6 units on the property. Thus, that's how it was noticed.
Thank you.
Yep.
Other questions? Just a couple. What kind of review have you done to see if there are other appropriate uses for that structure? I mean, I noticed in some of those, in that area, there are some of those historic barns that are used to store vehicles for other storage purposes.
As far as review, I couldn't say. I know my clients have thought about what other purposes it could be put to, and they, determined that, one other purpose could be storing industrial equipment, but that's really a detrimental thing when you're talking about, residences right there. They don't want heavy trucks moving in and out of there. They don't want plow trucks and dump trucks coming in and out of there. So that would be a potential use, but one that we believe would actually be more detrimental and harmful to this community than the one that we're proposing, as well as being less productive. That's just not as good of a purpose as creating 2 new homes for some families here.
I'm not seeing in the statute the necessity for the most productive use. I think what we're seeing here is there other use for this structure that's part of what it is. And I'm not sure that commercial is necessarily through the storage of huge machinery or whatever. There are other buildings in there, and we're trying just to find, we have to make the findings, so we have to ask the questions. It doesn't necessarily indicate our views. We're just looking for factual. Is there any reason why it couldn't be used for storage of cars? I mean, you've got a decent-sized parking lot there, but is there any reason why it couldn't be used just as some of the other properties where they have large barns to put 2 or 3 cars inside?
And ultimately, I don't know the answer to that question. I don't know the engineering requirements that would need to be in place, the foundation requirements that would need to be in place. I can defer to my clients to see if they have any additional information on that. But ultimately, we just aren't sure that would be a possible use for this.
Okay. Fair. Thank you.
Sort of as a follow-up to the chairman's question here, when we were out at the viewing today, there was a concern by an abutter on, we have a first floor plan drawing by Stokes Design in Sandwich, New Hampshire, that showed an external trash area. And there seemed to be some concern in the neighborhood about that structure. And as a follow-up to Fred's question, has there been any consideration, or is there any reason why that couldn't be placed inside that barn instead of using up the outside area and being right next to the fence?
Sure. And this is something. Sorry, go ahead.
Excuse me. And I would then defer a question to Matt as to the appropriateness of building that trash structure next to that fence because of setbacks.
Do you want him to answer first, or do you want me to?
Either one.
Okay.
So depending on the nature of this trash receptacle enclosure, whether or not it constitutes a structure, if it does constitute a structure, which we haven't seen a detailed plan for this, then I would say that it is subject to all setback requirements. If it does not, then it would not be subject to the setbacks. Based on what's shown here, though, I am concerned that this could potentially constitute a structure and therefore be subject to that setback on that side.
Thank you.
Yeah.
And so then I will speak to that in that the plan that was submitted as kind of the architecture for that was not the site plan. The site plan that we submitted, you'll note, does not show that structure. That structure is simply an option that could be considered. It was designed by the architect as an option to enclose the trash receptacles that are already there. My clients would not build that without going through the proper permitting requirements, any restrictions that are in place. That's not what we're asking for approval of in the variance. And so we certainly would not assume that we have the right to build that. It would have to be built according to proper permitting and any other restrictions that apply, including the setback requirements.
Other questions?
The 3rd floor plan is part of the 2nd floor apartment?
It is, yes. It's basically a loft bedroom above the 2nd floor.
It's not a separate entrance
It
house.
is not a separate entrance. There's only 2 units. There's no bathroom, no kitchen up there. It's just a bedroom for that top unit.
Other questions? Okay, for the moment, thank you very much.
Thank you, Mr. Chairman.
All right. At this point, we will ask if there's anyone who wishes to speak in favor of the applicant's request. If you do, please approach the microphone and identify yourself. You'd be eligible to speak in favor of your own request if you'd like. It's not necessary, though. All right, we'll defer on that while they consider. Is there anyone who wishes to speak against the application? Please approach the... Welcome back, Mr. Hausman. Long time no see.
Yes, thank you. It's nice to be back. It's the first time I've ever sat on this side of the table, so bear with me a moment.
You can let us know what kind of experience it is.
I will introduce myself. I'm Rob Hausman. Michelle, my partner, my wife, and I own 19 Pleasant Street. We have a common boundary to the rear of this property. We also own 18 Pleasant Street across the street from our house. We acquired that in 2012. It's a 4-unit building. And I stand before you today wondering if I should actually speak regarding this application, because I own an old Victorian house that I could benefit from converting to a multifamily, and I own a 4-unit that sits on a larger lot that I could have greater density if you were to grant this approval. However, I view zoning and the public process for changing zoning as an important process. So with that, I'd like to address the board on several issues that have been raised. First, the Village Residential Zoning District history. Prior to 2009, this property and the entire town had 3 residential zoning districts. That was GR1, GR2, and GR3. 1 acre, 150 feet of frontage for all 3 districts. In 2009, the planning board proposed a zoning amendment to double that density in the village residential zone. Yes, an increase in density, as the purpose states. I recall that the select board had concerns with regards to this zoning amendment and requested a build-out analysis to ensure we could absorb that development. That build-out analysis was prepared, and that zoning amendment passed. In addition, we have a situation where we allow the conversion of large, older, single-family homes to up to 4 units. Those 4 units required minimum lot area per unit, 7,280 square feet per unit, so slightly less than an acre for 4 units. We have a property here that benefits from a special exception, slightly more than a 1/4 acre, 0.26 acres, with 4 units on it. It would not be permissible today under either of our ordinances. One of the conditions approved for this use included the requirement for 7 parking spaces. I don't believe you can set aside that condition and allow 2 more units to benefit from the required 7 parking spaces. I would suggest you seek council's guidance on that, because the condition for the special exception runs with the land. Having said that, I'd like to touch base on a couple of other issues that I think are missing in the applicant's proposal and are raised in the applicant's proposal. One is the property at 98 and 100 North Main Street. Those are condominiums today. They have been multifamily for more than 20 years. They were converted to condominium back in the early 90s. My point in making this statement is there is nothing that guarantees properties to remain as rental property, and moreover, we do not regulate whether they're affordable, whether they're short-term, whether they're long-term, or whether they're condo converted. I can tell you that short-term rentals radically impact the character of the neighborhood. The individuals renting short-term are there for a purpose, to enjoy this lovely community. It's our bread and butter. But residential neighborhoods like North Main Street and Pleasant Street shouldn't be impacted by that type of development. Having said that, a reference to many multifamily housing units, there are 4 on North Main Street, 98, 100, the one 2 doors down owned by the same owners, and this one. So to my knowledge, there are no other properties like this. So speaking to the density at 98, 100, the density there would be less than the proposed density on this lot. Let me restate that. The density there will be less than the proposed density on this lot. We're talking about 23 units per acre on this lot if we do a multiplier of number of units per square foot. We have an applicant who's talking about the use of the barn independent of the use of the property, segregating a structure on the property as if that's independent from the overall use. Now, I'm of the opinion the use is on the property, not in a portion of it. Otherwise, each one of us could say, my garage, my barn, my house. And I don't think that's how zoning works. With that in mind, I have a couple of comments with regards to the standards for, I have one more comment, and I see Mrs., I don't wish to speak to one of the abutters, but I note that the parking is partially on the adjacent property. It was granted an easement. It was approved as part of the special exception because they were owned in common at the time of the application. You'll note in your packet you have a survey plan that references the layout of that parking lot. That parking lot, I believe, is the reference plan in the deeds for the adjacent property. You'll note that there is a bump out in that parking lot that includes an old crab apple tree, I believe it's referred to. If the easement truly represents that plan, then that's not the parking lot that exists today. And I don't believe they have, that's a question, a legal question. I'll leave it at that. Now, I'd like to touch on some facts in the application. We have a lot that's 0.26 acres. Minimum lot size is 0.5, 1/2 acre. We have a lot with 4 units that were approved by special exception to convert a duplex into 4 units. Today, if that were permissible under new construction, it'd be 1/2 acre per unit, or 2 acres to support this. That's the zoning requirement. If it were to convert a single family home to 4 units, that's 29,120 square feet for the existing 4 units. Again, the lot is 11,510 square feet. So approximately 1/3 the minimum standard for 4 units permitted today. 7 parking spaces required by special exception. I do not believe you can transfer that. I am not an attorney. I would encourage you to seek counsel's guidance on that. However, noting that, if they have 8 spaces and they're proposing, and 7 run with those 4 units, they need at least 2 more. The construction of a space today must comply with the side setback and rear setback, so 10 foot off of either property line. They could not accomplish that on this site. We have the issue of, and I have citations if you need them, but they're in your zoning ordinance. There has been reference to a building permit denial. I would encourage you to view that building permit. I have an electronic copy of what I believe to be the permit that was denied, and I can happily share my tablet. This permit application was dated 8/29/18, received September 4th, 18. If you look at the date on Corey Ryder's denial, that's September, bear with me a moment. 17th. It appears as though this was the referenced building permit, and I'll read from the line submitted by the applicant. Taking an existing 2-story barn used for storage, making the first floor storage space and office, and the second floor living space. That's what's submitted. Now, I don't know this to be the building permit that is referenced by Corey's decision, but I do have a date stamp plan that seems to contradict what we're seeing here today. With regards to I'll speak to my position. We're opposed to the approval of this application because the lot doesn't conform to the minimum requirements. The current lot size would only permit a single-family dwelling. The increase in density will adversely impact the neighborhood by increasing traffic and noise. Please note that each unit will generate additional trips. The Institute of Transportation Engineers suggests somewhere between 6 and 10 trips a day per unit. And while that's probably on the high side, that's new trips. I would also note that this is a public state highway that would probably trip a state DOT permit also for review. I just put that on the table for your consideration. Additional parking, I've already spoken to this. I believe that they are required to provide additional parking. Any new parking must fully conform. I'll note that the applicant is silent on lot coverage. Lot coverage for a lot greater than 0.25 acres is 30%. There is no indication as to what the lot coverage is. However, you have a GIS system online that allows you to calculate lot coverage, and it's in excess of 35%. Why is that important? The applicant may or may not have a deck on two sides of the building. That deck is considered impervious area. The applicant may or may not be required to connect the two buildings because of building code and fire code. I believe they must be connected, and if they are, that's an increase in lot coverage again. The applicant did not request a relief from lot coverage requirements. They requested a relief from the density requirement or multifamily units. So I believe that's an issue that's outstanding. Now on to the criteria that you must act on. Spirit of intent, public interest. The ordinance expresses the purpose and intent to increase density. As I spoke to you a moment ago, the history of this district went from 1 acre to ½ acre. That was the increase understood to be the standard for the town. I don't believe that the potential increase is appropriate for this lot, and I'll note that there are many lots of this size in this district. There are many lots of this size in this district. All of them have the same hardship. They have a substandard lot with an old structure on it. My house, 1800s. Building across the street, 18-something. You know, we all have that burden. We chose to accept that burden when we bought the property. Most of the houses on North Main Street, however, are single-family residential properties that have been invested in and well maintained. I make that note. Substantial justice. Granting the variance would not do substantial justice because the benefit is clearly outweighed. The benefit to the applicant is clearly outweighed by the harm caused to the general public and the abutters specifically. The applicant should have known the zoning requirements at the time it acquired this property. And if it didn't, I can't speak to that. The addition of 2 units provides a clear economic benefit to the owner while negatively impacting the abutting properties. Additional parking, whether it's provided or not, traffic, noise, headlights, glare, snow storage. You saw that today. They push it right to the back property line. I don't know how they would accomplish snow storage with a trash container there or the attached deck there. Those are things that are part of a functioning site. Those who maintain property for a living and own rental property understand the importance of having snow storage, especially on a year like this year. Value of surrounding properties. I'm of the opinion, and I'm not an appraiser, this would diminish property values. Increased traffic, increased noise, increased glare, all run the risk of impacting traffic. This is not an attempt to knock the owners, to do anything more than respect the fact that their intent is not the ultimate use necessarily. Properties change hands, economic situations change over time. The owner may choose to convert it to condominiums. The owner may find the need to have short-term rentals. If you check your phone or app today, Airbnb, you'll probably see 30 to 40 on North Main Street. Those are real impacts to the character of the neighborhood. Hardship. Finally, the standard of hardship. Hardship relates to the lot, the property, not the structure. What is the inherent hardship on this property that distinguishes from those properties in the neighborhood? I would say that this property already benefits from a special exception that treats it differently than those in the surrounding neighborhood. And there is no economic or real hardship that our zoning burdens this property with that's different than any of the surrounding property. As a matter of fact, they benefit from that special exception. To recap, the lot's too small. Lot coverage exceeds existing permitted lot coverage. The required additional parking, if you deem it appropriate, and I would encourage you to seek council's guidance on this, would need to comply with setbacks and would also create an increase in impervious area, making the lot even more non-conforming for lot coverage. We cannot and do not regulate number of occupants, we the town, nor do we regulate how cars park. I mean, this town cannot impose a condition that says 1 car per unit. And I just make that statement because as a father of 2 grown children, there were times when we had 5, 6, 7 cars in our driveway. Their significant others would come and visit. You cannot restrict the terms of rental. Now, I've heard affordable used. I will note for the record that the town has an affordable housing overlay district. That district was created to allow for means-tested, deed-restricted, affordable housing. This is not that proposal. That density allowed in the affordable housing standard is 4 times the density permitted in residential districts. That would be 4 units per acre in this zone. This exceeds that density. With that, I want to thank you for your service to the town. This is a challenge for you to consider this application. I'm grateful that you're here to hear this application. I'm grateful to have the opportunity to present to you, and I welcome any questions.
Questions for Mr. Hauser? We reserve the right to record it.
Duly noted.
Thank you. Anyone else wish to speak in opposition to the application? Please come forward and identify yourself.
I'm Becky Swaffield, and I live 2 houses down on Pleasant Street from this property on North Main Street. I just want to respond to some other things that have been said. I know that the board is aware of the zoning ordinance and all the points that have to be made. I think the barn, a logical use for the barn, considering they don't have enough parking now without the easement for their existing units, would be to provide a couple of parking spaces in the barn, or it could be used for storage. And I think that, one of the points of the variance is to show that there's no other use for your property for the use of the barn except for what they want to do with it. I don't think that point has been made. The other thing is they've been working on that barn for a long time before they even applied for a building permit. I don't know what they were doing. I haven't been on site, but I live close enough to know they've been working up there. And I just wonder, when the town is aware that someone is doing construction on their property without a building permit, why isn't that investigated? We had a similar thing happen on Mill Street. My husband and I own the Kingswood Press, and Rethreads, the used clothing store, was purchased, and people were working there on the building, inside and out, and we thought, wow, this is great, they're fixing up the building. And we didn't find out what it was going to be used for until we got a notice, from the planning board for hearing, and everything had already been made, done. They had a building permit that was, they hadn't gone to the planning board yet. I just think there's got to be some more oversight between the uses of property and when the building permits are issued and that sort of thing. There's no guarantee that these units are going to be affordable. My husband and I own a property next door to the press, the red building, and we have a 2-bedroom apartment upstairs, and my son lives there, and we've been told you could get $1,000 for that 2-bedroom apartment. Of course, we don't charge him $1,000 a month, but I don't think $1,000 a month is affordable housing in this town, with the state minimum wage being $7.25 an hour, and people who are bagging groceries or working at Blacks are not making enough to afford $1,000 a month, especially a family. If you have 2 different friends renting the place at $500 each, sure, you could probably make it work, but I think it's a little deceiving to call it affordable housing. And to say that this is a benefit to the town of Wolfeboro, I don't see that. I mean, I really think the main reason is so they can make more money off the property. There's nothing wrong with that. Everybody's trying to make some money, but to say that they're doing it out of the goodness of their hearts to benefit the town of Wolfeboro, which is really what I got from what the attorney was saying, I just don't think, I don't think that's true. We don't know how many people are going to be living in these units. We don't know what the length of the leases are going to be. Google Airbnb in Wolfeboro, New Hampshire, and you will not believe how many Airbnbs we have in our town. And I'm a little nervous about my residential district on Pleasant Street. What protections do we have from Airbnbs even? And I know that's another whole issue, but I hope the town is looking into it. I read in the Conway Daily Sun that the town of Jackson, you have to have a minimum of a 3-day rental, which that's a long weekend, but at least they're doing something, they're addressing it. But the house next door to me, the house across the street from me, they can rent them out for a week or a weekend or to a wedding party that's taking place at the Wolfeboro Inn. The house on the Wolfeboro Inn side of me has had 4 different owners since we moved to Pleasant Street. I really think we need to protect our residential districts. I'm not opposed to a building being turned into apartments as long as they meet the zoning requirements. And this project for 4 units had to go before the ZBA, and now they're asking for more units. And the point that the lawyer made, I used to be on the Board of Adjustment, and I was also on the Planning Board. I know what it's like to sit on a board, and I know the kind of pressure that's on a board, especially when you have attorneys coming before you talking about lawsuits before the Supreme Court, et cetera, et cetera. I remember one of the first cases we heard, we denied it, and it went to court, and the town won because there was another use for that property, or in this case, another use for the barn. It was not a hardship to turn it down. And I feel like the Board of Adjustment, which is not even an elected board, is probably the most powerful board in town because you are able to override the zoning ordinance and the wishes of the people of this town. And one reason that I think Wolfeboro is the nicest town on the lake is because we have strong, strict zoning. With the 150-foot rule that came into play back in, I don't remember how many more years ago, you couldn't have all these back lots have access to the lake. And look at Guilford, look at these other towns and what has happened because they didn't have a 150-foot rule. But I feel like you are the overseers of the zoning ordinance, and everything that's in there has been voted on by the voters of the town. And I think you need to really look at the points and see if this applicant does meet the points. They already have 4 units. They don't have enough parking as it is, and they can use the barn for something else. Thank you.
Thank you. Anyone else wish to speak in opposition? Sir?
My name is Peter Cook. My wife Patty and I own a home at 117 North Main Street, opposite and up a couple doors from the subject property. Fortunately, we have a former town planner and a former planning board member here tonight. So all I need to say is that I agree with them. We were in opposition for density, for precedent, and for all the other reasons they mentioned to you. Thank you.
Thank you. Anyone else wish to speak in opposition? Does any member of the board have any questions for those who spoke in opposition? Would you like to spend some time explaining to us why they're wrong?
Just address a few points very briefly, Mr. Chairman. A pervasive part of what was presented as a reason not to do this is the density requirements, and we fully acknowledge the entire reason we're here is that this is in excess of the density requirements under the Zoning Act. That's why we're asking for a variance here. But to cite that as a reason to deny the variance is circular. And so yes, we acknowledge that this is a request to exceed the density restrictions in place on this district. That's the entire reason we're asking for the variance. The parking issue, I believe, is a non-issue because we can all sit here and we can all have different opinions as to how many parking spots should be in a unit like this, but the ordinance itself specifies what that is, and the ordinance states that it's 1 parking spot per unit and 1 parking spot for every 3, 1 additional spot for every 3. And so in this case, that's very simple math, and it's 8 units. The idea that we would have to take the old ordinance's higher restrictions and carry them forward to now impose restrictions in excess of what the current zoning ordinance specifies, it's like we're inverse grandfathering, and it just doesn't make sense. And so I don't think that there's any issue when it comes to the parking because this is in compliance under the current zoning ordinance with the parking requirements. So I think that doesn't need to be addressed. It has also been referenced that we haven't asked for a variance as to the, and I forget the term, but basically the square footage of this lot, the percentage of it that is covered by structures. And that's very simple. The reason we haven't done that is because we are not proposing any modification as to the footprint, where everything that is being sought to be done here is going to be done within the existing footprint. And so we have not sought a variance request for that because the footprint itself is grandfathered. And so while that may be in excess of that percentage, we're not seeking a change in any way as to that. And then there was one additional point related to the benefit that this brings, and the idea that the entire purpose and what we're asking for is being obfuscated, that it's not beneficial to my clients. Absolutely, the heart of why we do anything with our property is so that we can use and enjoy that property, which is that's a valuable thing. That's something that we view as an inherent right in this country. That does not necessarily mean that it is not also beneficial for the community, and that's what our position is that they are making very intentional efforts to do something that is good for them. It is an improvement for them as the property owners, but they're trying to do so in a way that's also beneficial to the community, that preserves the integrity, the visual appeal of this area and the historic appeal of it. And so I don't think those two things are mutually exclusive. It certainly is, because it will make it a more beneficial property for them, but it's also that does not restrict or prohibit it being beneficial to the community. And so that just wanted to address those few points. Thank you, Mr. Chairman.
Anyone wish to rebut the rebuttal? This will be the last opportunity.
I'll comment on parking. And I'll ask you to be aware that prior to a legislative change that required the municipality to increase the number of units in a multifamily from 4 to 5, there was only 4 units ever allowed in a multifamily in Wolfeboro. So prior to 2013-ish, I think is when that statute was passed, only 4 units were permissible. I'm going to address now the administrative requirements for the zoning. You are obligated to take the most, not you, the board has great power. The zoning administrator, and I assume it's Mr. Sullivan, is obligated to take the most conservative and restrictive view in applying and interpreting these ordinances. The current zoning, and it relates to that pre-2013 change, would have required 7 parking spaces for 4 units. That's the most conservative provision of the zoning. It says 4-unit building, 7 parking spaces. That's what it says. Now there's a contradiction. The line above it says 1 unit per visitor, 1 unit per unit, 1 place per unit, and 1 place per 3 units, per visitor per 3 units. There's a conflict. I admit that. However, the zoning administrator is obligated to take the most conservative and restrictive view. 7 spaces, 4 units. Translate that, that's 1.55 units per, 1.55 parking, no, how am I doing this? 1.55 parking spaces per unit. That's the most conservative and restrictive view in interpreting this ordinance.
Thank you. I'll close the public hearing at this point, and I have a suggestion from my colleagues here. I see at least 5 questions that probably should require the advice of counsel before we go forward. And I would ask Mr. Sullivan, is it appropriate to ask our counsel to either appear at the next meeting or to provide us with written advice? And with that nod from Mr. Sullivan, which we can't hear on the audio tape, I would like to propose that we continue this hearing until the next meeting and that we obtain legal counsel on at least the 5 questions that I see. If someone has some others, I'd be happy to add them to the list. I think the first one involves the effect of the special exception and what that means in terms of the requirements for parking spaces. The second one I see, and this is sort of random order, is there a separate variance required in order not to connect the 2 buildings? The third one I see is there a requirement for the new parking spaces to meet a 10-foot setback? Fourth one is, would this qualify as affordable housing? I toss that in just as if we're going to ask for the lawyer's view, and this is the representation that's being made that this will be affordable housing. Is there another step that's required? And then finally, there was a question raised by Mr. Hausman as to what the building permit asked for, and if Mr. Hausman's copy of the application is correct, does this board have the authority to entertain an appeal from that which would ask for greater relief than what the original application requested? Anyone want to add or subtract to that? I'm good.
I just wanted to ask Mr. Sullivan, I know that the applicant's probably anxious to get moving or get an answer. This was delayed last month because they were supposed to be on in January, is that correct? So is there a way of expediting this and making sure that this happens? I'm sure the applicant wants an answer either way. And we're going to be going on 3 months of them being delayed in a decision. So is there a way to get this, make sure this happens by March 1st?
Well, it may be possible. I would not recommend continuing to any other special meeting of the board. I would recommend continuing to the regular meeting of the board. That would be my recommendation.
And that the date of that meeting is?
The date of that meeting is March 4th, I believe.
Probably would be, yes, March 4th. Is there any discussion on my motion? Certainly. Well, I'll reopen the public hearing. I'm sorry? Second, is there a second to the motion? Thank you.
I'll second the motion.
Is there a second? Is there any objection to my reopening the public hearing for one more comment from our applicant? Okay, no. Seeing none.
I just wanted to clarify something that may have been misunderstood. We are not seeking to have this be affordable housing under like the Affordable Housing Act. When I referenced affordable housing, I simply meant kind of residential dwellings available for us here in Wolfeboro, and you know, not the lakeside dwellings or the Airbnb, you know, but not referencing specifically affordable housing under the Affordable Housing Act.
Okay, thank you. So we'll remove one of those questions.
Would you like to remove question number 4, in which case I would re-second it with number 4 deleted? Okay.
The public hearing is still technically open, so I see someone who wishes to rebut the rebutters, rebutters.
It's a question for the chair.
Yes.
Do you intend to reopen the public hearing after receiving council's guidance?
Yes, I would. All right, motion has been.
I prefer not to.
Well, I think it may raise questions that I think, in fairness to everyone, even though technically I don't have to, I think I would do that. Thank you. I'll close the public hearing. There's been a motion made and seconded. Any discussion? Yes, continuing to a date certain, March 4th at 7 o'clock in this very room, assuming that it's available. All right. Any further discussion? All in favor, say aye.
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 Anyone opposed?
Opposed?
We will continue the hearing until March 4th at 7 p.m. Thank you, folks. We have the second item.
As second item, tax map 228-39, case number 02-V-19, applicant Warren and Jennifer Lynn Wilson. Public hearing for a variance under Article 9, Section 175-64A, 1 of the Wolfeboro Planning and Zoning Ordinance to allow for the construction of the 280 square feet, 14 by 20, one-car, 1.5-story garage with a 44 square foot gravel drive and raise a 52 square foot shed and remove 422 square feet of impervious driveway. This property is located at 56 Hopewell Point Road. A site visit will be held at approximately 4:25. It was held. Attending was Chairman Fred Tedeschi, Tim Cronin, Dave Senecal, Sarah Silk, Peter Colcord, Luke Freudenberg.
We're relocating one of the youngest members of the audience here. It's been outstanding.
Who's been extremely well behaved
Absolutely
and
outstanding.
very patient.
May I ask who appears for the applicant here?
So my name's Randy Walker. I work for Walker & Varney here in Wolfeboro. I'm representing Warren and Jennifer Wilson, who own property at 56 Hopewell Point Road here in Wolfeboro. And they're requesting, comparatively to the one you just had, a very simple, straightforward variance for a small structure, 14 feet by 20 foot garage, 1.5 story in size. The half story would be to put like a canoe or something up above, but not a second story for anything other than small storage. They also would add a 44 square foot gravel driveway coming in the existing driveway, taking a turn to get in, and plan on taking two things away to make this a productive application. They would remove a 52 square foot shed, as well as 422 square feet of impervious driveway. The plan there is to make the property overall more compliant rather than less compliant. So this is not an applicant that's just saying, please give me. He's willing to trade and give some things back to make it a worthwhile application. So to get right to the criteria, number one, the variance will not be contrary to the public interest. As noted in the Board of Adjustments handbook, for a variance to be contrary to the public interest, it must unduly, into a marked degree, conflict with the ordinance such that the variance violates the ordinance's basic zoning objectives. And to determine this, the handbook suggests you ask the question, does it alter the essential character of the neighborhood or threaten the public health, safety, or welfare? Now, we're in the shorefront residential district, and the purpose of that district is set forth in the ordinance is to maintain the integrity of the shorefront residential district and to protect the shorefront from overdevelopment. This proposed garage will be outside of the 50-foot setback and as far away from the lake as we could possibly get. The lot itself is 0.19 acres in size. It has approximately 55 feet of frontage on the road, roughly the same amount of frontage on the lake. The shed that is proposed to be removed sits both not only in the side setback, but it's also in the front setback. So we've got 2 violations of that existing structure, and that structure is proposed to be removed and replaced with a garage. And on the southern side, the J side, that's the house past this on the left, that side setback would be met with the garage. So currently there's a violation on that side. We're trying to pull the new structure away, put it more centrally located inside the lot. We cannot, however, comply with the road frontage setback of 30 feet because there's a septic system behind it. And the applicant initially wanted a 2-car garage, thought that was a little bit too much, is coming in for just a single car garage, just a 1-car garage, which again would meet side setbacks but not the front. This will be beneficial overall to the public, the lake, the town, and the neighbors because the overall impact from an impervious area perspective will be reduced. The current lot coverage is about 36%. If the variance is approved, it will be reduced down to 34%. Lot coverage will also be reduced. Another benefit from 32% to 30% is 422 square feet of impervious driveway will be removed, as well as the 52 square foot shed. So overall, there'll be an improvement in impervious area by 150 square feet. So the property from a lot coverage perspective will be more conforming. From an impervious lot coverage perspective will become more conforming, both in furtherance of the basic zoning objectives. This also will not alter the essential character of the neighborhood, which currently is residential, and it will remain residential. Overall, stormwater management should be improved because there should be less runoff given the increase in pervious area. This road's also a dead-end road, so there's not a lot of traffic coming through. You saw how narrow it was today coming in. If you went just past this house, there was also a garage on the right on the road. This one will be set back a little bit further, but our immediate neighbor has got a garage set even closer. So in proximity, comparatively, this will be set back. So the spirit of the ordinance, criteria number 2, is also observed, basically relates to the same criteria as number 1, but again, will not alter the essential character of the neighborhood, will not threaten the public health, safety, or welfare, in part because we're going to increase pervious area, decrease lot coverage, improve the side setback. We'll still have 1 violation on the front, which we currently have at the moment. Number 3, substantial justice will be done. The handbook suggests that this is a balancing test where the loss to the applicant has to basically outweigh any gain that the general public may sustain. And I believe this is a win-win for both the public as well as the applicant. The applicant obviously gets a garage where he does not have one now, while the public will be benefited by having the side setback improved, lot coverage improved, and the pervious area will be improved. Collectively and globally, I believe, does substantial justice. Number 4, the value of surrounding property will not be diminished because I have 2 letters from the only 2 neighbors, both of which are not opposed to this project. They're not here tonight.
Thank you.
Basically, the neighbors were consulted before we even came here this evening. Neither one had any objection. You'll see in the second letter they had a few suggestions. They wanted to ask the Wilsons whether they would keep their trash inside. That was their plan anyway. They were a little sensitive to some shrubbery. You'll notice that on the roadside there was a fairly good growth of hemlock trees that provide a natural barrier. They plan on keeping those there and remove the least amount possible. But we don't believe that there'll be any a diminution in value of property by putting this garage there. All the neighboring properties have garages all the way down the street. This will be the smallest garage on the street if you approve it. And then number 5, literal enforcement. of the provisions in the ordinance would result in unnecessary hardship because of special conditions that relate to this property. This applicant's lot is literally the smallest lot on the lake. And I was reading the tax card, and it actually says it right on the tax card. If you'd like to see it, I'm happy to show it to you. But it's a small lot. There's no other lots in the area that are this small. It also makes setbacks as a result very tight, given the fact that the shed right now encroaches into both two-side setbacks. The lot also is the only lot in the area, I believe, that exceeds 30% lot coverage. Everyone else is in compliance with that, and if you approve this, we'll be more compliant in that particular area. So there's two specific areas that suggest that this lot has some special conditions, and owing to those special conditions that distinguish it from other properties in the area, there is no fair and substantial relationship between the purpose of the ordinance and the application of those provisions. As noted in the handbook, and I quote, to answer the question on special conditions, this board should ask whether the restriction of the property is necessary in order to give full effect to the purpose of the ordinance, or can relief be granted to this property without frustrating the purpose of the ordinance. Is the full application of the ordinance to this particular property necessary to promote a valid public purpose? Once the purpose of the ordinance provision has been established, the property owner needs to establish that because of the special conditions of the property, the restrictions as applied to the property do not serve the purpose in a fair and substantial way. As we indicated earlier, we're in the shorefront residential district, the goal of which is to protect the shorefront. If you go by this property in a boat a year from now when this structure is built, you won't even know it's there. It's completely sheltered from the lakeside, and has a little buffer on the street side as well. So I believe it'll be an innocuous addition to the area. It's also outside of the 50-foot waterfront setback. In fact, all work is uncharacteristically as far away as we could get from the lake, rather than people usually are trying to push things closer to the lake. That's not the purpose here. And then is the proposed use reasonable? Again, having a one-car garage is fairly common today. Most of you probably have garages at your house. I know one doesn't.
I wish.
I know you were going to say
wish.
that. So if you'd like to come down to Hopewell Shores Road, about a
The
year.
Jeep just ran into the Honda because we don't have a garage last week. I don't want to talk about garages.
I knew you'd say that when I that was a little tickler. But most people today have garages, and most waterfront homes have garages. So it's not an unreasonable use to ask for a single one-car garage when almost all the neighbors on this street have either 2 or 3-car garages. Again, we're just looking for one. This garage you've built would also be the smallest garage on the street, which I think is consistent with the lot being the smallest. It's in scale relatively the same. So for all of those reasons, I believe that we qualify for a variance. I would respectfully request that you approve the variance. And I just had one last point. In looking at the plan of review, Matt, I'll say saliently, discovered that the plans that were in your package did not indicate how far the garage is going to be away from the street. It said it was going to be more than, not closer than 10, but more than 30 away. So he asked for a specific rendition of the plan that would give that notation in there. I sent it to Matt. I don't know if you provided it to them. All right, so I have more if you want it, but specifically the closest corner of the garage if built would be 11.6 feet away from the road. And I shouldn't say that. That's from the property line. The property line is actually set inboard to the road, so it'll be farther away from the asphalt. And then the next closest point, the other corner, will be 14.9 feet. I thought that was a reasonable request by Matt, and we had Randy Tetro, who did the survey, put those 2 dimensions in there so that it was very clear where that structure would be located. If there's any questions, I would be happy to answer them.
Any questions for the applicant?
Clear.
Anyone else wish to speak in favor of? I see a nod over here from the young fellow. Very happy.
Being very well behaved.
Indeed.
He's had a long day.
Anyone wish to speak against it? Okay, hearing nothing. Thank you, Counselor. I'll close the public hearing and we can have our discussion. Everybody's happy. Okay.
I
Any,
would just comment that I think it's very clear that there is extenuating circumstances on this lot, and the size really makes it much different from those others in the neighborhood. And if you look at that letter that the neighbor had submitted, there were a couple of requests about trash cans and shrubs and whatnot, and it appears that those questions have been addressed in this new drawing that we received.
okay. Other comments?
I have one.
Dave?
On this plan,
I think you have to make him acting, because he's an alternate. Or do we have anybody?
He's allowed to,
speak
he's allowed
to
to,
the issues.
he's allowed to deliberate.
just not going to vote.
Can't vote.
My thing was, you mentioned that those two numbers, the 11.6 and the 14.9, were just put on the plan. Okay, just note that the plan is dated July 2018. No, I just wanted to be sure that it wasn't, you didn't intend or mean that the thing was just done as far as the plan itself. Well, I don't know how important it is. I just...
It's not critical to us. The point is that the plan's right, but you absolutely are perceptive.
Any objection to reopening the public hearing?
No.
No. Counselor? Sorry. Now we can have an official response.
Dave appropriately picked that up. Obviously, that was the plan that was done 6-7 months ago. The application, it wasn't until Matt asked to change that they added it in, but it probably should be a revision date on that, but that was just put in today for the record.
I just wanted to be part of the record that that was done. I don't have any objection to it.
The applicant has indicated they accept those two numbers. Any further discussion? All right. I'd like to make a motion that we approve the variance request in case tax map number 228-39, case number 02-V-19, for a variance to remove 52 square foot shed, remove 422 square feet of impervious driveway, and replace that with a garage, a 1.5 story one car garage, 280 square feet in accordance with the plot plan that was provided to us, which includes setbacks from the property line. Making that decision, I think the board finds that the variance is not contrary to the public interest, because the public interest is largely to maintain the shorefront from overdevelopment, adding an additional garage, and removing all of a good deal of the impervious pavement and surface that will increase the amount of pervious payment and will make the property a little bit more conforming in the furtherance of the zoning ordinance, and will have less storm water runoff, which would benefit the public and the water quality. We find that the spirit of the ordinance is observed because it does not alter the essential character of the neighborhood, nor will it threaten the health, safety, or welfare of the citizens of Wolfeboro. In fact, it will help the health, safety, and welfare by increasing the pervious area. We believe that substantial justice is done here because any loss to the applicant would certainly outweigh any potential to the general public. The general public also benefits from the removal of a shed that was non-conforming and encroaches, and also the removal of a significant amount of impervious area. Fourth item, the value of the surrounding properties will not be diminished. There has been no testimony at all that there will be any diminution in the value of the property. And finally, the board finds that there are special conditions of this property that distinguish it from all other properties in the area. It apparently is close to, if not the smallest lot on the lake. The purpose of the ordinance is to prevent overdevelopment and maintain the integrity of the shorefront residential district. This does not in any way overdevelop the shorefront, and the renovations will have no impact on, changes will have no impact on the 50-foot waterfront setback. In fact, it will make the property more conforming and we believe, therefore, the applicant's proposed use is reasonable in scale and consistent with the neighborhood. Is there a second to the motion?
Second.
I will second the motion if you include the planner's
Yes.
comments.
Could I actually amend one of my recommended conditions as well?
Sure.
Condition number 6, I'd like to amend to a minimum distance of 11.6 on the northeast corner of the proposed garage and a minimum distance of 14.9 feet on the southeast corner of the proposed garage into the front setback shall be verified by a licensed land surveyor in accordance with the approved plans.
If you'd like to incorporate that, I would second that.
I will incorporate those as Mr. Sullivan,
Seven conditions?
as Mr. Sullivan has revised the conditions. Is there a second?
Yes.
All right, Sarah seconds it. Any further discussion? All in favor?
Aye.
Say aye. Anyone opposed? Your variance is granted. Thank you very much. All right, the last item on our agenda tonight is to review the minutes of the meeting of January 7th. Anyone have any comments on them?
I did not. I would make a motion to accept them as written.
Is there a second? I'll second the motion. All in favor?
Aye.
Anyone opposed?
Abstain.
I did have one other thing I'd like to bring up. I had a problem with my packet for the Hopo Point. I had page 345586788. If somebody could just like proofread these packages.
The pages, some of the pages appear to be out of order.
Fred's packet was the same as mine. It goes page 345, then I have a duplicate page 5, then it's slipped in a page 8 prior to page 6 and 7, and then I had 2 more copies of page 8. Yeah. So if they could just check them before they go out, that would be great.
Need a motion to adjourn?
All in favor of adjourning?
Aye.
Any opposed? Vote meeting is adjourned.
Did I hear Luke second that after Dave made that
Shoes
motion?
on.